so that they feel more empowered to, especially victims of domestic abuse and violence. So the bar would be higher.
I know you described yourself as both an attorney and a coach. What does that mean?
I offer coaching services. I'm still a lawyer. I'm not like a coach in the way that other people, but I will consult with clients while they're going to mediation. So they go to mediation on their own, and then in between mediation sessions, I meet with them, usually on Zoom or by phone. We go through numbers, we talk about different issues and strategies that they might use so that they feel more empowered to participate and advocate for themselves in the mediation session.
Okay. I know, like you said, mediation is voluntary, it's confidential and flexible, and it's less expensive, so to speak. But when you go to the courts, it's made public.
Yes.
And it's formal and rigid, and the cost is quite high, enormous, so to speak, and it's adversarial.
Yes.
So when is it the best route for couples not to settle for mediation but rather go to the courts?
I think that the court, they have to be there. We need them. We need the judges to be available to help, especially victims of domestic abuse and violence. They need to be able to address the really significant cases and to make sure children are safe. And sometimes that's what you have to do. Sometimes people are afraid to go to court, but that's what the judges are there for, to be that backstop. Sometimes you might, at the beginning of your case, you may need to get temporary orders to make sure that the mortgage is being paid, to set even just a temporary parenting plan so that everybody knows where the kids are going when. That can take a lot of stress off, to have some sort of schedule and financial plan while you're doing discovery and trying to determine what a fair resolution of the whole case would be. And sometimes at the beginning of the case, it can be bumpy, and it is necessary to get temporary orders. Sometimes you don't need that, and people can work those things out voluntarily to come to stipulations for a schedule or for support or whatever the case may be, and you can avoid court that way as well. But court, it is expensive, it's not private, and it can be stressful being asked to make decisions in the hallway of the courthouse, for sure. So it's you have to talk with your lawyer every step of the way, because there are usually different options available at different points for how to proceed.
Thank you. I totally see what you're saying, especially when it comes to the 50-50 default cases, when there is one parent is saying, I have right to equal time. But when it comes to when it comes to domestic abuse or high-risk cases, is that applicable? Because I don't think it's applicable in the UK. The child safety overrides parental contact rights.
So in Massachusetts, our statute has a presumption against shared custody if there is a history of significant physical abuse. So the bar would be higher, I guess, for the abuser to convince a judge that it would be appropriate if there's a history of that. But a lot of times it's more diffuse than that, and maybe there's not one clear example, or it's just a pattern of more subversive behavior, and so that can be difficult. Sometimes you might need what we call them guardian ad litem, is basically an investigator appointed by the court to talk to children, talk to teachers, pediatricians, and people like that, and report back to the court on a parenting plan.
Thank you so much. Be safe and be positive. And don't forget to check out our social media handles. Thank you. Bye for now.